appraisal of the problem, or in the Court of Appeal's appraisal of the problem, of a real weighing of the risk of what I think counsel for the defendants at the time called overcompensation, i.e. a risk that because there'd been a widespread attempt to bribe the jury, then the defendants must be guilty.
Alright, yes, so welcome again, viewers and subscribers, morning, evening, night, whenever you check in as usual. Yeah, man, you're tuned to RyanmediaTV. If it's the first to tune to this channel, please click the subscribe link, click the bell to be notified for any brand new video. And if you're tuning in, man, just please like this video, because you don't know it, go always update on upon Wagwan. And we jump up early this morning, because I say, yeah, me want to see everything want go on, you know. You see me viewers, and I jump up and I tell you, say, yo, now the first half, me see the judge or the Privy Council, the lords them, so them call themselves the lords and the lady. Yeah, man, them a give the prosecution a beating about the jury. Yeah, man, and that could play a vital part in this case to me, in a Vybz Kartel being released. You see me? But down the line, me have a next video me I go share in a next vlog where me I tell you, say, yo, you see, when the man bring up the evidence about Vybz Kartel and how the house get burned down and when Sean Storm carry them at the yard, trust me, that part there look lethal. You see me, that part they look like a dagger in the heart. Yeah, man. So, me not telling a lie, this can go both ways, viewers and subscribers. You see me? Yeah, man. But what me I go do? Me I go play the first part, because you don't know no one gonna everything in one video to make it too lengthy. So, we are going to go on this piece first, and then see if me can follow up and go on the next piece after this. So, tune in to these viewers and subscribers, and if you reach this far in the video, have it like the video as it, yeah, man, please to do so. Big up on yourself, subscribe as well. So let's go into it.
Are you suggesting that's a targeted direction? It might be said against you. He's just repeating what he said right at the start of the trial. He's had a specific allegation made, and all he's done is to repeat what he said to the jury at the start of the trial.
Well, without adding quite a bit of the stuff he did say at the start of the trial, summing up. That is true. My Lord, I fully accept it is not targeted. The question is overall. The overall question is, did the jury, is there a real risk the jury was influenced against the appellants? I submit no. They've got the message from the judge loud and clear all the way through.
Do we see anything in either the judge's appraisal of the problem or in the Court of Appeal's appraisal of the problem of a real weighing of the risk of what I think counsel for the defendants at the time called overcompensation, i.e. a risk that because there'd been a widespread attempt to bribe the jury, then the defendants must be guilty?
My Lord, I think it's fair to say there is no... Well, the judge himself, obviously, he doesn't, because
he's obviously heard the
split decision. Yes, no, he doesn't. No, he just goes ahead. It's a fairly short. The trouble is, it's all dealt with very quickly. It's
and the Court of Appeal don't seem to address their minds to that issue.
Not quite clear to what extent that was. One of the problems is in the Court of Appeal, as far as one can tell, that doesn't really appear to be the main thrust of the appeal. The thrust of the appeal was more investigation should be made by the judge. The bias point it was there, but it wasn't, so to speak, centre stage. That's my understanding. And so that, no doubt, is why the matter doesn't receive the attention which now it's been subjected to. But, my Lord, the next question is, if I may, was there a real risk that the trial was unfair? I submit that is the ultimate question. That is to say, unfair by reason of subconscious prejudice, conscious prejudice against the accused because of the bribes that have been offered, apparently in their interest. I say there is no real risk that the 10 jurors who voted to convict were influenced to do so by their knowledge that bribes had been offered by the miscreant juror. And first of all, can I just make this point? I submit it as more accurate to describe the question as one of prejudice than as one of bias. The reason I say that is this. Bias generally, in general language, arises as a result of an internal disposition which affects a person's whole way of thinking about a case or about a matter. And this, in my submission, is a heightened, and therefore there's a heightened risk that a juror won't comply with his oath. Supposing I'm an absolute out-and-out racist, I believe all black people are useless or bad. You're never going to get rid of that. The problem is you're very likely, it's just me, it's part of me. Or let us say I'm a Chelsea fan and I'm a referee in a Chelsea game. I'm just going to give all those split decisions to Chelsea and so forth. It's just in me. I can't help it. That's, in my submission, bias which is irremediable. But there's, at the other end of the spectrum, there's prejudice which arises as a result of, or potential prejudice, which arises in the mind of a neutral person, or neutral jurors, which comes about as a result of an external event, such as here. Or it could be, let's say in the course of a trial.
I mean, the paragraph, the second sentence on page 5869.
Yes.
That approach, on the face of it, looks somewhat problematic, I would suggest. That we don't want to investigate much further because the likelihood is we're going to have to discharge the jury.
Well, my lord, one has to see that in context. He's saying with nothing has been gained and a great deal that we've lost the possibility of having to discharge by questioning the accused juror. So he's not just saying, the Court of Appeal is saying what was to be gained by questioning the accused juror. And in my submission, that was a perfectly proper approach. I mean, one does ask, what was to be gained by...
But it's an acknowledgement that that juror was not going to abide by his oath, isn't it?
Oath. Well, it's an acknowledgement that he may well not abide by his oath. That is right. I cannot deny that there was obviously a risk, bearing in mind...
Well, more than a risk, it was...
A likelihood, maybe. So far as one could tell, one only has an allegation. But I come back to the point I made yesterday.
Well, if it was just a risk, then he would have investigated and impressed upon the juror the importance of not being affected by extraneous considerations.
I can see that. But even if one allows that, you have my submission yesterday, if the risk is just that one, or probability that just that one juror is not going to perform his duty, that in my submission is not a reason for discharging the entire jury if the prosecution, who are affected by that bias, says carry on anyway. And that you might say is a pragmatic point, but in my submission that is a perfectly proper approach for the court to take. If it is, I mean, it wouldn't be right the other way round. If there was a juror who's biased against the defence, that might all be very different indeed. But here we are talking about the state who's bringing the charge in the public interest, who knows there is a problem with one juror. But one juror is bent against the prosecution, come what may. Let us assume.
But the real problem which we're facing isn't it that there was a risk that the whole of the rest of the jury were biased against the defence?
My lord, I accept that's a different risk, if I may, for the moment. That is a different risk. But just as far as questioning the individual bad juror, my lord, and that was the point which this particular paragraph is on, I submit that there was nothing to be gained. There was indeed. What's he going to do? He's just going to deny it, probably.
Yes, but it is really the point I think that Lord Burrows was making, that if you read on, saying a great deal would have been lost by questioning the accused juror. And what would have been lost would have been the trial, because if the accused juror had admitted the conduct alleged, then not only he but the entire jury would have had to be discharged.
Well, my lords, I submit he wouldn't necessarily have to discharge the jury, even if, let us say, the individual juror had said, oh, I own up. I did try to bribe them. My lords, it all goes back to the single point. There's a different point that Lord Briggs makes, which is about the introduction of the rest of the jury, but it's just this one point. Supposing the judge is entirely satisfied that 10 jurors can perform their duty properly, I'm sure they're able to do it. But he knows that one is very unlikely to do so. Supposing that is the position, the question is, as a matter of law, must he discharge the jury? That is the question. And if the answer to that is yes, he must, then I accept I'm in difficulties. If the answer is no, he doesn't have to, if the prosecution is content to take the risk that this one juror is just going to vote against the prosecution, come what may, in my submission, he's entitled to do that.
I think the answer that would normally be given is you must discharge that juror.
If of course, I agree with that. In normal circumstances.
So if we assume that the legal position is you must discharge that juror, what is then your submission?
Well, in my submission, if you absolutely must, in all circumstances, even in a case such as this, where you've got right to the end of the trial, you can have a 10-1 verdict, and so forth. If you must, then my lords, I accept. Then what has happened is that the verdict that was given by 10 people who were entitled to be on the board of the panel, and one person who wasn't. And then the consequence of that would be, I suppose, that you do not have a quorate verdict.
The implication of your submission seems to be that in a criminal trial, and you could hardly have a more serious trial than this, where you have 5 people accused of murder, clearly there's a public interest in a true verdict being returned. The implication of what you're saying seems to be that the judge really has no responsibility in that regard. He's entitled, if the prosecution are willing to run the risk of the jury being nobbled by the corrupt member of the jury, that's a matter for them, and he can go along with that.
My lords, he has to be satisfied that the other 10 won't be nobbled, or it's very unlikely they'll be nobbled. I'd accept that. But if his thinking is, and I submit it was likely to have been this, I've got one bad juror here, I've got good reason to suppose the other 10 will behave properly. That means there will be, the jury will be quorate at 11. In my submission, he is entitled, he is not bound to say, I've got to stop the trial now. He has a power to allow the trial to go ahead. That is, and my lords, I accept that is the kernel of my submission. It has to be one which he exercises not entirely unreasonably in all the circumstances of the case. That is why I'm making the submissions I have been.
If it were the case that the same rules applied in Jamaica as apply in England and Wales, that is, you could have had a jury of 10, what would you then say?
My lord, I think I'd be bound to accept that the judge would have said, let's go down to 10. He probably would, in those circumstances, have said, balancing.
So the problem that you're faced is a system that doesn't allow a jury of 10.
That's exactly the problem. The whole problem.
An unfair trial, it might be put against you, is allowed because the rules don't allow a jury to go around to 10. Is that right?
No. I'm not saying that. I'm far from saying that. As long as the trial is fair, overall, I haven't come to my point about the fairness of the trial, but as long as the judge is satisfied that a fair verdict can be returned, even though one juror appears to be bent on assisting the defence, the judge can say that of the lesser of two evils is that the trial goes ahead, the administration of justice is served by the trial going ahead, and there is no common law rule that requires me to stop the trial.
The corrupt juror might be critical, his vote might be critical to whether there was a majority or not.
It might be. But in those circumstances, that is a risk that the prosecution takes.
Well, that's the point. You see, that's the point I'm jibbing at, really.
Yes.
The idea that responsibility for the administration of justice in the public interest is the responsibility of the prosecutor and can effectively be waived, if you like, by the prosecutor, rather than being the responsibility of the court.
Yes, I do accept that, but my lord, it is still the responsibility of the court. If the court is satisfied...
But we see the problem. if you're presiding in a criminal trial where a majority verdict can be returned, and you know that one of the members of the jury, or you have good reason to suspect that one of the members of the jury may be corrupt. For all you know, the way he votes in the jury room could be critical to the verdict that's returned, and could result in a wrongful acquittal, for example.
My lord, again, I come back to my point. The judge is entitled to weigh up all the different evils. I mean, the real problem is that the judge was caught between two evil solutions.
Yes, I've got the greatest sympathy for the judge. And I mean, in this country, we would think twice about rerunning a 67-day trial. But in a country like Jamaica, the expense involved in this, apart from anything else, is enormous.
But, my lord, my submission is this: as long as the prosecution is acting responsibly, and as long as the judge is acting responsibly and reasonably, rationally in making these decisions, and as long as they are satisfied that overall there can be, not necessarily that there will be, but there can be a fair verdict, if there can be, then in my submission the lesser of two evils is to go ahead and get that fair verdict, rather than simply say, trial off, no verdict, which in real life may well mean no trial whatsoever. And that is why I say one must look. It's not just a matter of sympathy for the judge, it's what is the responsible, forgive my putting it this way, the responsible response to this very, very difficult situation. Which is the lesser of two evils? And my submission is the lesser is to go ahead in the hope that there can be a fair verdict. You may well land up with an unfair acquittal. That is one risk you take. But it is better to take the chance of getting a fair verdict than to abandon that altogether.
That fair verdict would be reached in circumstances where the allegedly corrupt juror would not only have a vote, but he'd have the opportunity to influence the other members of the jury.
Well, he might still seek to influence the other members of the jury, but he wouldn't. Sorry?
In deliberation.
In deliberation. He can still say what he likes in deliberation. He can still draw attention to a good point, let us say. That can still happen. He's not prevented from doing so. He may well be able to persuade one of the other jurors, not by offering money.
Well, by offering money.
No.
But he may.
No, he may be able to persuade one of the other jurors in deliberation. Look, forget about my bribe. These people are innocent because of point X. He's still entitled to do that.
Well, he's entitled to do that, but he's not entitled to persuade them by offering them bribes.
Certainly
and that is an ongoing risk.
That is, my lady, I accept that is an ongoing risk.
Yeah.
That must be right, is a risk. He will try again.
Yeah.
I mean, you might think it's a bit unlikely if the matter's been reported to the judge, actually, but there's a possible risk. Let us say there's a possible risk. My lady, even in those circumstances, if that is a risk which the prosecution is prepared to take in order to achieve a verdict, that is the lesser of two evils, and if both the judge and the prosecution think that is a proper way of proceeding, they can. That is my fundamental point. And one of the problems with jury trials is one is trying to create a system of perfection. In one sense, of course this is not perfect. No one would begin to say it's perfect. But is it, in fact, the pragmatic way forward, which did, in the event, secure a fair verdict? That is
but the defendant's counsel didn't accede to this way of proceeding. That they continued to raise well, on the face of it, it looks as if they were objecting.
They did. There's no doubt about that. But they were objecting for different. They weren't objecting on the quorum point, but they were objecting because of the way it's put. I think by one of them is the overcompensation point. I'm concerned about it, and that's a fair point.
Yeah.
I'm not saying it's a bad point, but in my submission, it's not a conclusive point. The judge is entitled to say, well, I'm still prepared to put this matter to the jury because of the various points I'm going to come to later, because the strength of the case, I've been assured that I will give another direction. I have already given directions about not being persuaded by extraneous matters. The judge in my submission, and this is in a sense the heart of the case, was he bound to stop it? My answer is no, he was not bound to stop it, for the reasons I've given. And I do submit, I take my Lord's point about the Court of Appeal's judgment, but I do submit this is important to bear in mind what the Court of Appeal had to say about this matter. They have familiarity with how juries work, how the system works, and it's their primary responsibility to ensure the criminal system works properly. You are operating as a second review court. This is a point to me made again and again. And I do submit great respect should be given to the Court of Appeal's assessment on this point.
Well, it will be.
But so, my Lord, you have my point on that. So I say there was no error of law in what the judge did. That's what it boils down to. He acted within his discretion. It was not an unreasonable decision to make, given the extremely difficult circumstances in which he found himself, and the possibility there could still be a fair verdict. That's the point. My Lord, can I just turn to the judge's directions, because it's important, it ties in with the previous point. I've already given you references to some directions before. Can I also ask you to go, please, to E4723 to 4, which is what he says to the jury right at the beginning, which is a resounding direction in my submission. E4723.
All right, so we reach the end of this video. If you haven't liked the videos yet, please to do so. If you reach this far and you haven't subscribed yet, please to do so. Yeah, man, as you can see the face of the prosecution team when, trust me, come like this is for them. Maybe me not say weekend, so them have to ensure so them do the right thing. But I just say me gonna left it. Remember to follow me on the IG. Big up on yourself.